In this video, we are continuing our discussion about certainty of subject matter, which is the second of our three certainties. And in the previous video, we were looking at trust of bulk or interchangeable property and also intangible property. And in this video, we're going to be sort of continuing that sort of discussion, but talking about separate bank accounts. And this has got a load of different cases that we're going to look at to show how the case law has progressed. So the separate bank account. Now, in this case, Channel said that it is clear that if the terms upon which the person receives the money are that he is bound to keep it separate, either in a bank or elsewhere, and to hand that money so kept as a separate fund to the person entitled to it, then he is a trustee of that money and must hand it over to the person who is his cestui que trust. If, on the other hand, he is not bound to keep the money separate, but is entitled to mix it with his own money and deal with it as he pleases, and when called upon to hand over an equivalent sum of money, then, in my opinion, he is not a trustee of the money, but merely a debtor. All the authorities seem to me to be consistent with that statement of law. So this is quite a contentious area of law. The question is whether you can have a trust over money in a bank account if the trust money is mixed in with non-trust money. In other words, can you have a trust over part of the money in a bank account, or is it held that trust money mixed in an account with non-trust money is fatal to the formation of a trust? So you can see how this sort of discussion about separate bank accounts really leads on from the previous video about talking about intangible property. And in this case of Henry and Hammond, the High Court said that if the trust money is placed in a separate account, there will be a trust, but if it is mixed in, it cannot be a trust. Okay? However, things aren't always so simple, and the case law seems to shift around a little bit in this area. So we've also got the case of Cayford, and it was said by McGarry that in Nanwa gold mines, the money was sent on the faith of a promise to keep it in a separate account, but there is nothing in that case or in any other authority that I know of to suggest that is essential. So McGarry in this case said this quote here, and he says that he doesn't think you need a separate account to set up a trust. So he almost is saying the opposite thing here. And in Hunter and Moss, it was said by Colin Reimer that if, however, A has only one account with a credit balance of £2,000, Mr. Hartman submits that a purported declaration of trust in respect of £1,000 standing to the credit of such account will only be valid if and when such sum is first withdrawn from the account and identified as a distinct fund, and that the court would be impotent to enforce the purported trust before that had happened. As to the latter example, I can see no reason in principle why this should be so. So this says that a separate bank account is not required. So at the moment, as the case law progresses, we got this case in 1913 of Henry and Hammond, we got the case in 1975 of Cayford, and we got this case here in 1993 of Hunter and Moss, and we're now 2-1 in favour of not needing a separate bank account to create a trust. However, in this 1996 case of Islington, it says, second, since the depositor's money in Sinclair and Brofman was intended to be mixed with that of the society, there was never any intention that there should be a separate identifiable trust fund, an essential feature of any trust. So this is the usual authority and an extremely important judgment, and the case really says that trust money must be kept in a separate account to set up a trust. And then we've also got the case of Lehman Brothers for 2012, and Lord Collins in this case, however, and it's a more recent case by the Supreme Court, actually provided a contradictory authority and says there is no doubt that money in a mixed fund may be held on trust, and that a trust of money can be created without an obligation to keep it in a separate account. So the question is then, do you need to have a separate bank account to form a trust? And to be honest, I actually have no idea. And I actually suspect the courts don't know either. Most people do seem to think that a separate bank account is essential, but the authority, the authority on this is far um, from certain. It's certainly a lot more contradictory. So the position appears to be that if a person receives money on trust, they are bound to keep the money in a separate bank account. If the terms of the agreement under which the money is received allow the recipient to mix their money with their own, this is inconsistent with, but not necessarily fatal to, an intention that the money is held on trust. So a requirement that money should be kept separate is strong evidence that a trust is intended. However, a person may declare a trust over a sum of money in an account which includes other money. So a person may declare a trust over a mixed account. And so this is a controversial and not entirely resolved point. Case law just simply is not very consistent on this. And there is one particular case that I do want to look at in a bit more depth before I finish off my discussion about certainty of subject matter, and that is the case of Fair Pack Food. And FFG was a Christmas club run as a business. Customers made small weekly payments to an agent. Before Christmas, they could use their accumulated funds to buy Christmas hampers from the company. And in October 2006, FFG ran into financial problems, and on the 11th of October, it ceased trading. So, let me explain. Many thousands of low-income families participated in a Christmas fund whereby they contributed a few pounds each month throughout the calendar year. So they would have saved up a large amount of money by November so that they can spend it on Christmas gifts or festive foodstuffs and so on. And these families would pay the money to an agent who would put the money into Fairpack's account. The Christmas food could be taken in the form of Christmas hampers or presents provided by means of shopping vouchers. The Christmas fund was therefore a pool of shared money contributed by the various customers. And the Christmas fund was managed by a company, Fairpack Foods and Gift, and that's called FFG. And FFG's directors decided to cease trading on the 11th of October 2006 after running into some financial problems. On the same day, the directors executed a deed of trust declaring that they held all monies received into their customer's account on or after that date on trust for the benefit of the customers. So, before its insolvency, attempts were made to create a new bank account into which any further customer contributions to the Christmas fund would be paid so as to keep those further contributions separate from the other assets of FFG. So any money received on or after the 11th of October was to be held on trust for the customers. The principal question was whether or not these funds were to be deemed to be held on trust for the customers who contributed to them. So the court held that there was no express trust. The money was received by the company when the customers paid the agents, usually in cash. Accordingly, it was not possible to say whether the money paid into the account on or after the 11th of October had been received before or after the date on which the trust had been declared. So the court had to decide whether or not there was sufficient certainty of subject matter and sufficient certainty of objects. That is, on the facts, is it sufficiently clear which customer's money was paid into the Christmas fund after administration began? So it was not clear when money was received before the date of the trust and when money was received after the date of the trust. Okay. Those who paid before the 11th of October were existing creditors of the company before it entered into insolvency, putting their money into trust and thereby preferring them to the other creditors is forbidden by insolvency law. It is avoidable preference. That's the Insolvency Act 1986, section 340. So if the customers paid before the 11th of October, that is before the date of the trust, the customer is merely a creditor, okay? He or she will have no proprietary interest in the money he hands over, and all he can do is join the other creditors and hope for a distribution when the company is being liquidated. Those who paid their money after the 11th of October would, if the trust had been formed, be beneficiaries of the trust declared. And beneficiaries retain their beneficial interest and would therefore get all their money back. So they set up a trust to try and save some money for some customers. If someone is a creditor of a company and someone pays their debts in preference to other debts, that is avoidable preference under company law. It is against the law to favour one debtor over another as a general rule. So the point is that the company had to distinguish between those people who had paid the company before the 11th of October and would therefore have been merely debtors and would have been against the law to favour them, and those who paid after the 11th of October when the trust was formed, and they would be the beneficiaries under a trust and could recover all the money paid. The problem was determining when the company received the cash, because the company referred to those collecting the money as agents. The court had no choice but to accept that they were agents, okay? In other words, they were acting for the principal FFG. So if you pay money to an agent, it is the same in law as paying money to the principal itself, paying money to FFG. So if the agent went around on the 10th of October to collect money, the company would have received it on the 10th of October. So that person would be a debtor. If someone paid directly to the company by bank transfer on the 11th of October, that person would be a beneficiary. So if an agent who received money on the 10th paid it to FFG on the 11th, that person would have been a debtor. Because of this sort of issue of distangling which customers had paid on which date, the trust ultimately failed. It was impossible to tell which property was a debt, that's money paid to an agent before the 11th of October and paid in after the 11th of October, and who was a beneficiary, money received and paid after the 11th of October. So as I just mentioned, there might have been an express trust in favour of any customer who had paid into the account directly, but the practical and evidential difficulty meant that the court would not find that the money paid into the account on or after the 11th of October was held on an express trust. So it didn't fail because it was a mixed bank account, and that's important to bear in mind. It might have failed on this ground, but this was not the ground on which the trust actually failed. Okay, so that is the end of certainty of subject matter. We've now looked at 2 of our 3 certainties, and in the next video we're going to be looking at the third certainty, and that is certainty of objects. If you have any questions about this video, please leave a comment below and I'll get straight back to you. And don't forget to like this video and subscribe to my channel. Thank you very much for watching.